number 9, my lord, with the instruction of my client, I beg to withdraw this petition, lord. Item 9, lordship,
You want to withdraw this petition?
on instruction of my client, my
Mr.
P.K. Bodole.
P.K. Bodle, the learned counsel appearing on behalf of the petitioner, submits that submits on the instructions from his client, from the petitioner, that he wants to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. Ms. So-and-so appears on behalf of the respondent number 2, 3.
Here is the interim order. Also. Interim is also.
The interim order passed earlier stands vacated.
May I please, your lords? First, I beg to mention item 44, 45, and 48. This thing matters, my lord, I am not pressing it, my lord. 44 and 45, my lord, contempt matters. The petitioner got the relief, my lord.
Huh?
44 and 45, my lord, the order has been complied with. These are contempt matters, my lord. And so far 48 is petition, my lord. Here also, my lord,
44 and 45. No,
44 and
let's first go into 44. What is the order?
so, my lord,
No. What is the date of the order? Item number 44.
That is my lord 2523, my lord.
Huh?
Order is my lord 2523, my lord.
In repetition number? I'll do it. You come when the matter reaches. If you are not aware, don't mention it. Next. Yes, Mr. Mishra.
If a respondent file the affidavit in opposition, I need to file my claim. I am paying for 10 days time only, my lord.
Huh?
I am paying for 10 days time to file my rejoinder, my lord. Respondent has filed the affidavit in opposition.
Interim order?
No, my lord.
Okay. At the request of Mr. R.S. Mishra, the matter stands adjourned to be listed after 4 weeks. Full stop. In the meantime, he would be at liberty to file the reply to the affidavit in opposition filed by the respondents.
Deeply obliged.
Next.
Civil bench one, lordship.
No civil bench one.
Should review your lordship just. Must make it mention before this bench. Review of your lordship judgment in one CRP your lordship had disposed of. I have filed one review. So any date lordship.
Okay, next week. Next.
Apply. The day my lord. Actually matter is the NRC matters, my lord.
Item number 12, you want an adjournment. At the request of the learned counsel for the petitioner, matters stands adjourned to be listed after 2 weeks.
So matters next week, my lord, any date, my lord.
Next week.
Item number 41, lordship, not breaking, lordship. It has become infructuous.
Why infructuous?
Lordship, because body has already been constituted, lordship. There was direction to allow the petitioner to file his nomination. So he is not pressing, lordship.
You cannot say that you are not pressing a contempt petition. You cannot withdraw. Why is it infructuous?
Lordship, because the body has already been constituted.
So what? What was the direction passed?
Direction to allow the petitioner to file the nomination paper.
So the nomination paper, you have filed it.
Not filed.
The learned counsel appearing on behalf of the petitioner submits. Mr.
R. Islam.
Huh?
R. Islam.
Mr. R. Islam. Mr. R. Islam, the learned counsel appearing on behalf of the petitioner submits that in spite of the directions passed by this court, pursuant to the directions passed by this court, the petitioner had duly submitted his nomination paper, but could not succeed. Full stop. He therefore submits that the present contempt proceedings have therefore become infructuous. Taking into account the above, the instant contempt proceedings stands dropped. Mr. So-and-so, Ms. So-and-so appears on behalf of the respondent number 1 and 2. 1 and 2? Yes, Mr. Sikdar.
Does to have the matter listed day after tomorrow.
What is that?
Sir, relating to Panchayat election.
Day after tomorrow. Monsoon?
Maybe good. So I'm making a prayer, we have Mr. S. Chamaria, my lord, his father-in-law expired, my lord. So item number 14 and item number 49 to 53, my lord, they are contempt matters, my lord. I'm for a petitioner, my lord.
49 and 50.
49 to 53, my lord, the tag matters. sir.
Okay, Mr.
A.N.
M.
Sharma, my lord.
Huh?
A.N. Sharma, on behalf of Mr. S. Chamaria.
Mr. A.N. Sharma, the learned counsel, appearing on behalf of the petitioner, seeks for an accommodation on the ground that Mr. S. Samaria, who was leading the matter, the learned counsel who was leading the matter, he is indisposed on account of his father-in-law's death. Also taking into account the above, list the matter after 2 weeks.
I'm deeply obliged.
It's all option.
Yes,
He has decided to withdraw this petition, or to pray for a withdrawal of this petition by law, because they decided to comply with the directives given by the protocols.
you want to withdraw the petition without liberty.
But
Why?
if at a later stage,
Why? What is the case for?
my lord, it is for payment of the central minimum wages. We are paying the state minimum wages, my lord. Their contention is that we have to pay central minimum wages for the workers which we have outsourced in the Guwahati airport. my lord. So we are paying the state minimum wages. We were paying the state minimum wages. Now we have decided that we'll pay the central minimum wages and comply with the directions passed by the Labor Commission.
So therefore, where is the question of here? Here you have you are challenging an order dated 14/10/2020. Now you want to comply with that. So therefore, nothing remains. Mr. P.D. Nair, the learned counsel, appearing on behalf of the petitioner, submits that the petitioners,
Petitioner.
the petitioner is willing to abide by the order dated 14/10/2020, passed by the
My lord, the chief, sorry, my regional labor commissioner, Central Guwahati,
where is that order?
my lord. It is at annexure 27 from page 126 of the writ petition.
Passed by the Regional Labor Commissioner, Central Guwahati, which have been impugned, which was impugned in the instant proceedings. So taking into account the above, nothing further remains in the instant proceedings. And as such, the instant proceeding stands closed. Interim order, if any, stands vacated.
Interim order vacated. Interim order.
Any vacate.
Deeply.
I'm for the
Mr. S.K. Medhi appears on behalf of the respond numbers.
all right.
All the. Mr. Sharma, what is this?
Okay, contempt proceeding.
Where is the order? What is the direction?
Order is at page 13.
Now this has not been complied with.
Okay.
Have you written it to the Deputy General Manager? No?
No, yeah.
Huh?
There,
Where have you submitted the documents?
we have submitted the document
Where?
before the authority. After getting my documents by annexure 6 page 23. Page 25.
This is a letter written to you.
Yes,
Now I'm
Yeah.
asking you, when did you submit those documents?
in the time.
When?
Within the period of 6
No,
months.
no, there's no period given out there. The direction is that you are directed to submit the documents mentioned in the letter dated 8/4/2000 to the DGM so and so, who shall thereafter take a final call. Now, when did you submit these documents?
The petitioner accordingly directed to submit the documents. Procedure, paragraph 8, my lord, the petitioner accordingly directed to submit the document.
Or you submitted on 10/6/2024. Okay, issue notice making it returnable on 11th of August 2025. 11th of August, no, on 18th of August 2025. Steps be taken upon the respondent, upon the sole respondent by way of registered as well as usual. Pustak. Within 3 days. Pustak. You want to take Dusty? In addition to that, liberty is given to the petitioner to effect service by way of Dusty upon the respondent, routed through the registry of this court and file an affidavit of service on or before the next date. Pustak. The petitioner herein is aggrieved by the non-finalization of his bill pursuant to the directions passed by this court on 4/3/2024 in WPC number 53.
There are three W. And the common order has been passed.
In the common order passed in WPC numbers 5335/2021, 5255/2021, and 5297/2021. Full stop. It is the specific case of the petitioner that pursuant to the directions passed by this court on 10/6/2024, all the documents were duly submitted, but in spite of a passage of more than a year, no payment has been made. First, taking into account the above, the respondent is directed to bring on record their stand by filing the affidavit on or before the next date.
Next two cases are same.
Same.
Next two,
Why you are filing one then?
there are three civil votes, three petitions.
Oh, these are different, nah? Okay. In all these cases, you have submitted on 10/6. Same order. Same order. Here also same order. Okay, which is in which connection? Then if you are filing three, each are in connection with a particular matter, nah? Which writ petition? Ask your junior to give it to her. Silent. Which matter is in which case? Because you are filing three.
Three.
এখানে he order to in WPC number so and so. Second to in WPC number so and so. Third in WPC. You give ask your junior to give the dates.
Valid.
Yes, Miss Borua.
And she might sit the contempt petition. my lord.
Contempt. Why they have not complied? What is the direction?
The issued order is page 14 and the relevant portion of the order page.
In view of the grant form has now been converted to an application for grant of license, and as the petitioner has submitted the required fees prior to, the server is directed to take a decision on the petitioner's application for grant of license within a period of 3 months. Now they have not taken any decision.
Not yet.
Who is there for the excise department? Anybody from excise? Nobody. Nobody from excise. Hello. Issue notice. We're making it returnable on 13th of August 2025. Not 13th, 2020. 28th of August 2025. And why are you making so many people a party?
Because my lordship, in the order, respondents were directed, the honorable court directed
What?
respondents. In the.
What
impute
is the
order,
chief secretary going to do with the grant of your license?
Because the cabinet decision was taken in that petition, cabinet, in which the chief secretary has taken the decision and who has given one order.
Now, have you written it to the
Yes,
chief secretary?
See, because in the order, all the respondents were directed, so I have,
But how do I know that they have received it?
my lordship, I have at page 18, my lordship, the consignment report.
Huh?
Track consignment report, page 18. In each of the cases, I have submitted the track consignment delivered report.
Required to issue notice against everybody.
Because my lord, in the.
The
impute
decision is to be taken by whom?
order- My lord, the impute order, at page 16, the state respondents were directed.
R.R. Gogoi, the learned counsel, submits that he has got no objection to the prayer made by. They have been not taken a decision on the petitioner's application for issuance of law. Submits that the issue with petition can be disposed of if a direction is issued to take a decision on the petitioner's application for iman. No excise department? Check. Issue notice making it returnable by 28/2025. Steps be taken by way of registered as well as usual within 3 days. So in addition to that, the petitioner is given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. First up, the petitioner herein is aggrieved by the non-compliance to the order dated 8/1/2025, passed in WPC number. Petitioners herein are aggrieved by the order dated 8/1 by the non-compliance to the order dated 8/1/2025, passed in WPC number 6920/2024, whereby there was a specific direction upon the respondents to take a decision on the petitioner's application for grant of IMFL off license within a period of 3 months from the date of receipt of the certified copy of the order. Full stop. The learned counsel appearing on behalf of the petitioner submitted, petitioners submitted that all the respondents herein were duly informed about the, were duly served copies of the certified copy of the order dated 8/1/2025, passed in WPC number 6920/2024, and even after the passage of 3 months having elapsed, there has been no decision taken, and it is under such circumstances the present contempt proceedings have been initiated. First of taking into account the above, the respondents are directed to bring on record their stand by filing the affidavit on or before the next date.
Must utilize my lord.
May I please, Lord? Take application, my lord. Direction at page 9, my lord.
Yes.
Page 9, my lord. Relevant portion at page 11, paragraph 4.
Which department?
My lord, it's a BTC, my lord.
Yes, BTC, any counsel? No counsel from BTC. What is wrong with these departments, the government departments? Then,
Then, my lord, I have filed the representation at page 12, my lord. It is a non-payment of contractual bill, my lord. The petition was filed. Wait, my lord, the representation, my lord. Till date, no compliance.
you are directed to pay in terms with Tamsir Ali. How is it possible to you that you will be paid as per Tamsir Ali? Tamsir Ali says that you will be put in that particular what do you call? Yes, Mr. Gogoi, B. Gogoi. What does Tamsir Ali say? Chronological. Then, how is it possible that if it is chronological to pay you within 3 months? Is it heard of? How this can order be complied with? Supply order and the liability amount payable to the petitioner in terms with Tamsir Ali, and the respondent shall accordingly do the same within a period of 3 months from the receipt of the year. The payment of the admitted will be made within 1 month thereafter. How is it possible if On one hand, Tamsir is to be followed. How can there be a direction to pay within 1 month? Tell me, is such an order compliable? Doesn't it goes against the very decision in Tamsir Ali?
29 April 2024, man.
29th April or maybe in 2021 also, or during the midst of the COVID also. But tell me, how is this order compliable? If you are brought within the ambit of Tamsir Ali, you will be paid as per the serial number.
He may have a case, provided he can show that someone below in the list have been paid, leaving him.
That is only the case you can have a contempt. But how can you be paid within 1 month? This type of order is going to will be causing a havoc. Because on one hand, you are asking Tamsir Ali to be followed. And on the other hand, you are asking 1 month. Tell me, give me a good reason.
Since it's lapse of already 1 year, my lord.
You must have forgotten that I am very strict when I am issuing notice in contempt matters. Tell me, how is this compliable? Nobody can pay.
To take instruction on that, my lord.
Fantastic. Take instructions. Mr. So-and-so submits that he will take instructions. List the matter next week.
I'm deeply aware.
Great people also.
Hmm.
It's a contempt matter, my lord.
Non-payment?
Non-payment of the contractual fee, my lord. The direction your lordship will find at my lord, page 15, paragraph 13.
Non-compliance? No GMC?
Let the notice go, my lord.
No GMC council? Okay, issue notice making it returnable on 22nd of August 2025, steps be taken upon the sole respondent?
Sole.
Upon the respondent, sole respondent by way of registered as well as usual during the course of the day. In addition to that, the petitioner is given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is aggrieved by the non-compliance to the order dated 10/5/2024 passed in WPC number 2371/2024, whereby there was a specific direction upon the respondent number 3, that is upon the respondent herein, to verify the claim of the petitioner and pay to the petitioner the executed quantity of the work done as measured by the concerned divisional engineer in presence of the third party monitoring agency engaged by the GMC. It is the specific case of the petitioner that the certified copy of this order was served upon the respondent on 4/6/2024, and in spite of a passage of more than a year have passed, no steps in that regard have been taken. So, it is under such circumstances the present contempt proceedings have been initiated, the respondent is directed to bring on record their stand by filing their affidavit on or before the next.
But on more prayer, madam. But the post title, madam, the address is now different, madam. I may be allowed to file an eminent post title.
What?
The address of the respondent.
The address is GMC Commissioner.
But it is written, Nagar. Now they have shifted to Honest.
Do whatever you feel like you have to file an amendment application. I cannot allow you to do like this.
The running section, madam.
Withdraw
No, madam, there is a
with
procedure.
liberty? Then don't say main. Yes, what is this? Mr. Rashid?
I file I am only for to impede the similar as a respondent party.
Huh? What is this case about?
Case regarding a payment of the
Non-payment of dues. You are appearing for
Appearing for water resource,
1,
1, 2, and 3.
2, and 3. Okay. Verify and pay. What is it? I'm not going to exercise anything. Verify and pay. If you have to pay, pay. If you don't have to pay, don't pay. Water resource.
I am a party.
Now, water resource, there is a problem. Now, some amount will be from the central agency or something. Is it, has anything to do with the central agency? Hello? Issue notice making it returnable on 8th of September 2025. Steps be taken upon the respondent numbers 1 to Ms. So-and-so appears on behalf of the respondent numbers 1, 2, and 3 and accepts notice. Taking into account that all the respondents are duly represented, extra copies of the petition be served upon her during the course of the day. It is the specific case of the petitioner that the petitioner had completed the work, have completed various work pursuant to work orders dated 12/5/2008, 16/5/2008, and 19/5/2008. Of the said amount, however, the petitioner hey, this is the second round.
Well, earlier I find that nothing was done, then we file an application, notice, my lord. Then they said, yeah, our amount is due, that is we pay.
Huh?
Our amount is due, my lord, till date.
There's some amount payable to you. No. Why did you file the earlier petition?
Earlier it was long back, we are probably to
Understood. How can you keep on filing it?
they should notice, can you see, my lord, that it is not legal notice, we have seen and they forwarding legal, my lord, page 34 year lords, can you see.
Will be available, will be disposed of directive to proceed with the claim of the petitioner in terms of Tamsir. Then,
my lord, 34 my lord, gives us.
then
Earlier was disposed of, and that was we pay, but nothing was done.
legal notice issued so and so. Payment of Ilman as directed by the Honorable Vigilance in this context, the hearing to be proceeding on procedure between non is not given in the light of the comfortable critical revision the electoral commission with What is this? You have no case. This is the second round of litigation. Then earlier then, if you have not filed, you given legal notice that you are going to file a contempt. Now you realize that you cannot file a contempt and therefore file a writ petition. Absolutely no.
There is no any other way.
Again, we are going to pass an order of Tamsir Ali. We can't pass any other order other than Tamsir Ali. Then, which has already been passed in 2015.
Nothing has been done.
So, if nothing has been done, then you should have filed a contempt. Then how are you filing a writ petition again? No case. We dismiss your writ petition. First dismissal of the day. Okay. Huh? No. This is not a case. Amount of in 2008, you could have. These are amounts of 2008. You, after 3 years, you file a writ petition. On the motion day, you take an order up to 2011. We are thereafter, after 14 years, now you are opening your eyes. Therefore, we dismiss. Heard Mr. Mr. A.R. Rashid, the learned counsel, appearing on behalf. Heard Mr. A.R. Rashid, the learned counsel, appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent numbers 1, 2, and 3. So the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition without prejudice to his rights to proceed against the Withdraw the instant immediate. Taking into account the above, the instant petition stands closed on withdrawal. The IA stands. Yes, what is this?
My lord, this is for non-payment of higher charge bill.
How many years?
For 2 years, just
Which year?
from 1/1/2019 to 31st/12/2020, madam.
9 lakhs.
Yes, my lord. 9 lakh something. Madam. 9,06,076, madam.
Issue notice making it returnable on 15th of September 2025. Mr.
Ji Gokulia.
So appearing on behalf of respondent number 1, 3, 4,
and 5.
and 5. Mr. B. Gogoi appears on behalf of the respondent number 2. Full stop. As all the respondents are duly represented, extra copies of the writ petition be served upon them during the course of the day. The petitioner herein is aggrieved by the non-payment of his dues of an amount of rupees 9 lakhs 6,076, which the petitioner claims to be entitled on account of his vehicle being taken on hire. Full stop. The respondents are directed to bring on record their stand by filing the affidavit on or before the next day.
Oblige.
Yes.
Non-payment of contractual. And the total amount due.
This bench has nothing else. It has become a civil court. Mr. Chaudhary?
Yes.
This bench has become a civil court. Which year?
Hello, 23 and 24.
Good.
Allotted page 80. It will be clear.
I am thinking of one thing, to finish off all these things by putting a mark out there of 3 years. And if it is delayed by 3 years, no more. So I'm bringing it very clear to all the lawyers that don't file any writ petition delaying of over 3 years. The moment I get one, I'm going to pass an order. Thereafter, we'll see what has happened. Because the question of Tamserali was a one-time exercise, isn't it? And it cannot go on because the records get lost. You cannot have after 3 years. And there are many judgments of the Supreme Court which says that if by way of ordinary civil litigation, you cannot get it, but there is a bar. There is also a writ cannot be issued. Hello. Here,
For Gunotsav, boats were hired. 17 numbers of boats. For
how much amount?
I left 4,14,000.
No, why are you not filing a summary suit? Why not filing a summary suit? So representation's over. Go and file a summary suit. What is this? Where is it admitted that this amount will be paid?
Hello, at page 80.
80. Yes. Who has admitted?
Hello, this is written by the circle officer.
With regard to I will forward herewith that so and so bills are duly checked and countersigned by the Iman and found to be in order. The bank details of the vendor showing are included herewith for necessary payment.
And we kindly see the next page with the bill. It has been countersigned by the block.
This is 3,06,000.
Hello, this is for 23 session. There is another bill for 24.
Where is that?
That is on page 86. Madam.
Where is it? Amount?
Hello, the amount that part which they have submitted the bills, that bills we don't have the copy.
Then?
But it is there with the department, my lord. We kindly
Then
see.
why have you
I have
not
the honor to
enclosed?
submit
You
here.
got everything except that.
I have submitted here with 6 numbers of machine code in connection with bills with so and so. The bills are duly checked and found to be in order. The bank details are showing.
How much is the bill for?
That is in respect of 1,14,000.
1,08,000.
1,08,000.
Okay, issue notice making it returnable on, and why you are making everybody a party unnecessarily?
My lord,
Who is going to pay?
is the orders have been passed by the mission director. The orders have been passed under the mission director block, Sarva Shiksha mission.
Ah.
And thereafter, my lord, it is the commission.
Sarva Shiksha mission, you are Sarva Shiksha. Then why you are making the finance a party?
Because ultimately the funds will be released by the. That is why.
Is it? You will be releasing it. Finance, what? And what is the district commissioner doing?
Because ultimately the bills are placed before the district commissioner forwards it to the concerned department.
Okay. Issue notice making it returnable on 22nd of September 2025. Mr. So-and-so B. Chaudhary appears on
Or-
behalf,
2 and 8,
appears on behalf of the respondent numbers
2 and 8.
2 and 8. What about 4?
4 also.
2, 4 and 8. Miss so-and-so, your education, school education is who? You. Appears on behalf of respondent numbers 1, 6. 1 and 6. Mr. Bokoli appears on behalf of respondent, 5 and 7. And Mr. B. Gogoi appears on behalf of the respondent number 3. As all the respondents are duly represented, extra copies of the requisition be served upon them within 3 days. The case of the petitioner the case of the petitioners or petitioner?
Petition.
One petitioner.
One petition.
Then how are you entitled for everybody?
Not my lord, everybody, only for one only I am playing.
Oh,
Because the boards have
how
been
much you are entitled to?
4,14,000.
Let us see one thing very well. Kindly come to the other one,
Second bill,
page 80.
86.
Oh, these are. The petitioner herein is aggrieved by the non-payment of the due of an amount of rupees 4,14,000 to which the petitioner is entitled to on account of machine boat hiring charges for Gunostov 2023 and 2024. Full stop. The respondents are directed to bring on record their stand by filing the affidavit on or before the next date. Pendency of the writ petition shall not be a bar in releasing the payment to the petitioner if the petitioner is otherwise entitled to.
And deeply.
Yes, Guwahati High Court. What is this?
Grade 4 employee, my lord.
Ah,
Was attached in the office of the subdivisional judicial magistrate, Maparita, my lord.
what has happened to you?
By way of a disciplinary proceeding, my lord, he was awarded compulsory retirement from service, my lord. Then he had an appeal before the respondent number 1, my lord, but appeal has not been disposed of, my lord. So in the meantime, 8 months has elapsed, my lord.
You have been compulsorily retired. Now you are challenging that punishment.
Disregard an appeal was filed before the respondent number 1.
And the punishment has been, and the appeal has been dismissed.
No, my lord, appeal has been filed, my lord, but appeal has not been considered till date, my lord.
Huh?
Appeal has not been considered, my lord.
Who is it? Mister, appeal is filed before whom? The Chief Justice.
No, my lord. As per Rule 13, an order passed by the CJM is appealable before the district and session judge. But here, my lord, he has preferred the appeal before the second judicial department, LR.
Oh, then go and file it properly. Then what is this?
Rule 13, my lord, it provides of Ministerial Service Rules 1987. Every member of service shall have the right to appeal from the orders of the Chief Judicial Magistrate to the district and session judge and from the orders of the district and session judge to the government in the judicial department.
Appeal has been filed before whom?
Appeal has been filed before the LR.
But some district court employees rules have come into effect. Okay. Draft me. One draft?
No, it is not, I think. Because
Some district court employed service rules 2025.
Chief Judicial Magistrate, my lord.
Huh?
He is an employee of the Chief Judicial Magistrate. There is another rule, Assam Chief Judicial Magistrate, Ministerial Service Rules 1987.
No, I'm not on that. I'm only asking whether the Assam district court's employee service rules have come into being. No. Okay, now appeal. Where the appeal is rule 13. Every member of service shall have the right to appeal from the order of the Chief Judicial Magistrate to the district and session judge, and from the order of the district to the government in the judicial department. Now, who has passed the order?
Chief Judicial Magistrate.
Where is that order? 34.
Fine. The relevant portion, page
Final order.
52, 53,
Final order is being passed by the
page 53. 52 and 53.
we have passed like a judgment.
Yes, my lord. Page 52 and 53 is the operative portion.
So it has been passed by the Chief Judicial Magistrate. You are to file the appeal before whom? Why you are filing before the LR? And then now coming before this court that they have not considered. Why will they consider? Therefore, heard Mr. A.H.M.R. Chaudhary. The learned counsel appearing on behalf of the petitioner, Mr. So-and-so, appears on behalf of the Guwahati High Court. You are appearing? Appears on behalf of the respondent number 1. The petitioner herein has approached this court by exercising, by invoking the extraordinary jurisdiction of this court on the ground that the appeal filed by the petitioner before the legal remembrancer and secretary to the government of Assam Judicial Department, Dispur, Guwahati, against the order dated 12/9/2024, passed by the learned Chief Judicial Magistrate Tinsukia, have not been considered. Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, draws the attention of this court to the Assam Chief Judicial Magistrate Establishment Ministerial Service Rules 1987, and more particularly to Rule 13, which stipulate that any order passed by the Chief Judicial Magistrate, the appeal lies to the district and session judge, and from the orders of the district and session judge to the government in the judicial department. Full stop. From a very perusal of Rule 13 of the rules of 1987, it is therefore clear that the petitioner have wrongly filed the appeal before the legal remembrancer and secretary to the government of Assam Judicial Department, Dispur, Guwahati, rather than filing before the district and session judge. Which one? Tinsukia. Full stop. Taking into account the above, the question of issuance of a writ directing the legal remembrancer and secretary to the government of Assam Judicial Department to consider the appeal filed by the petitioner does not arise. Be that as it may, as the petitioner have wrongly filed the appeal before a wrong forum, it shall not bar the petitioner to file an appeal before the proper forum, and if so filed, the learned district and session judge Tinsukia may consider the same. The district and session judge may consider the same in accordance with law. So the period from 6th of November, it is also noticed that the petitioner on wrongful the petitioner had on wrong legal advice, had filed the appeal before the legal remembrancer come secretary to the judicial department of the government of Assam. Full stop. Considering the above, comma, the period from 6th of November till date be excluded while computing the period of limitation in preferring the appeal.
Much of.
It depends on filing.
What? You have got too much. Don't ask anything more. I gave you many more. Yes, Mr. Hendik. Yes, what is it? Non-payment?
Actually, my lord, not
Non-payment? What is this?
Actually, the matter is related to some service benefit, my lord. By an office order dated, my lord, 10/8/2020. It is in page number 27, my lord. That, page number 27, my lord.
What do you want?
Now is entitled to get this benefit there.
Yes, Mr. Kotoki, what does the petitioner want? He has submitted some representations. He wants this consideration. I am not going to pass an order for consideration unless he has got a good case for that. Now the question is whether he is entitled to any amount.
My lord, what happened in this case? He resigned from the post in 23/3/2015. At that time, probation period was 2 years. Subsequently, that was reviewed in 10/8/20 after his resignation. Reviewed from 2 years to 1 year and giving effect to the employee 2011 to 13. Thereafter, in 26/5/22, that benefit was extended to the employees 2007 to 2010 employees, those who were appointed. Now, Lord, he has resigned in 2015 itself. He claimed that.
But why have you given effect to after retrospectively? Why have you given effect to retrospectively? Issue notice making it returnable on 24th of September 2025. Mr. S. Kotoki appears on behalf of all the respondents. Footnote, extra copies of the writ petition be served upon them during the course of the day. Footnote, the petitioner herein is aggrieved by not extending the benefits in terms with the office order dated 10/8/2020. And in that regard had submitted repeated representations which have not been considered. The respondents herein are directed to bring on record their stand as to whether the petitioner is entitled to the benefits in terms with the office order dated 10/8/2020. On or before the next day. You file the affidavit next. No.
One thing, please, your lordship. Column has come impleadment of petition, but application, I am for respondent number 234 National Highway Authority of India. I have not received that impleadment petition. Who has filed? I will do not know also.
Who has filed this?
I don't know.
I'm being informed by Mr. Mohan, the leading counsel of this case, my lord. He's at legs before the state forum, my lord, district forum.
Which forum?
State consumer forum, my lord.
Fantastic. Ask him to go there. Appear before that. Will let us pass an order that this writ petition be laid before that court. Then
Can take it up after some time, my lord, please, sir.
absolutely no. Who are you? You are the writ petitioner.
Yes.
Who has filed this impleadment?
You have not received a lot.
Who has filed the impleadment?
No, because you have not received.
P. Mohanto has filed the impleadment. Impleading whom?
I'm
Oh, the counsel appearing on behalf of the applicant does not have knowledge about the matter for which the matter stands adjourned to be listed after 4 weeks. Next.
Fine.
Give your name.
Okay, fixing any date?
No, after 4 weeks. They let them be more, they let them read the file properly. It may take after vacations, October vacations. We have just finished the vacation. Yes. What is this? IA for?
Impleadment of party,
Whom do you want to implead?
chief engineer is the party.
Chief engineer? Why?
In the last updated version, both was of the opinion that the chief engineer should be the party.
Which chief engineer? Public health? Who is public health? You are? Oh, you are public health. Chalo. We have no objection. So this is an application filed by the petitioner to implead the chief engineer, comma, public health engineering department, Hengrabari, Guwahati 781036. Hengrabari 036? Okay, 036. As the respondent number 5 to the accompanying writ petition. The counsel appearing on behalf of the respondents do not object to the application. Full stop. Accordingly, the chief engineer, public health engineering, comma, department, and engineering department, Hengrabari, Guwahati, PIN 781036, Guwahati, Assam, is impleaded as the respondent number 5 to the accompanying writ petition, comma. The petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days from today, and on the basis of the said memo of parties and the order passed herein, comma, the registry shall make necessary correction in the cause title and update the same in the CIS. Full stop. IA stands accordingly disposed.
17.
Same?
Same.
Same? Yes, what is this? Matter pertains to bench 4. What is this?
Your Lordship, this relates to the non-payment of contractual bills, even after performing the contract. There is a long checker display. I performed the contract for the Sports Authority. of-
Non-payment of contractual bills. We have filed the affidavits. We should admit this petition. We should admit this petition. Let us come up after 4 years. No, no.
I'm for train.
Let it come up after 4 years.
So Your Lordship, I'll just make.
Nothing
just-
doing. Go to
I
the
have been
Supreme
paid
Court.
part payment. Should the entire payment.
Part payment, whatever payment, wait. This is not, there is no urgency. It is seen that the pleadings, it is seen that the pleadings are duly complete. Accordingly, list the matter for hearing on 4th of November 2025.
Should the PWD is yet to require the file their affidavit.
Oh, you have not filed it?
So far as the sports authority is concerned, madam, the sports authority, Assam, they have already filed it, they have disputed the claim of the petition.
Is it?
Yes.
So let's dismiss it then.
Your Lordship, then Your Lordship, to hear it, Your Lordship.
No? It's disputed, you go there.
No, there is no dispute. May I just present the facts for Your Lordship? Sports Authority.
Is the PWD required to file affidavit as per you?
Yes, Your Lordship.
You are PWD?
Yes.
You don't want to file?
They have issued the tender works, Your Lordship.
I'm asking you, do you want to file the affidavit?
There will-
Mr. B. Gogoi appearing on behalf of the PWD submits that the sports authority that there are certain disputed questions of facts for which the PWD would like to bring on record their stand by filing the affidavit. Ustam, list this matter on 27th of August 2025. In the meantime, the affidavit be filed. What is this? Okay, none appears on behalf of the petitioner on call. Any interim order is there?
Yes,
No interim order, na?
in my respective submission, in my respective submission, the matter has become infructuous. Because if Lordship kindly takes up the writ petition in 8198 of 2022, there they have prayed that
1898.
yes, Lord 1898,
What is the case of?
but they prayed that the impugn order passed by the district magistrate is to be suspended and the petitioner be allowed to run the bridge.
What?
There is a bridge over the river. And the petitioner's claim is that they have constructed the bridge by putting their own money and they should be allowed to collect toll for using the bridge. Well, we have filed an
Call for the
affidavit
records and issue a rule calling upon the sorcery should not be issued to setting aside the impugn order issued by suspending the right over the existing wooden bridge over Jaljali River from collecting. Mandamus should not be directing to forfeit, restrain and forbear from moving. So there is some order by which their right to collect toll has been
suspended.
suspended. Then
But now the affidavit, we have filed an affidavit on 27/1/2025. We have said that already that bridge is not in good condition and the movement over the bridge has been stopped. So there is no use of the bridge. If Lordship kindly takes up the affidavit filed on 27/1/25.
okay, then
So the bridge is not in operation and everything has been stopped.
but you have stopped them from collecting toll.
Yes.
Because of the bridge. Now you see that the bridge is inoperational.
It cannot be used. It is related condition.
But that doesn't makes their right to, they can repair.
PWD to remove that bridge and to construct a RCC bridge over that place.
You know, why they were collecting toll at all?
Their case is that at one point of time, a wooden bridge was constructed by them by putting their own money. And they should be allowed to collect the toll so that they can reimburse their invested amount. So that cannot be done, because that's not it will amount to a this illegal collection of money, the contract. The public body cannot be allowed to do that. So therefore, the order NHA 8 space 37 was passed by the Deputy Commissioner. But now the condition of the bridge is so such, it cannot be used by the commuters. And everything has been.
So if the commuters don't use it, then obviously there cannot be any collection.
So that has become infructuous, so that.
No, it cannot be infructuous. How can it be infructuous?
To use.
We should not. I think we should, as their petitioner is not represented today, we have it some other day, unnecessarily, yeah, and point it out that you will say that it has become infructuous. Full stop. None appears on behalf of the petitioner on call. Full stop. Mr. D. Nath, the learned senior government advocate, appearing on behalf of the respondent, submits that the instant writ petition has become infructuous in view of the fact that the breach upon which the petitioners claim a right to collect toll is no longer usable and operational. And as such, the question of having a right to collect toll does not arise. So taking into account that the petitioner is not represented, this court for the day is not represented, this court would not like to pass an order today. Full stop. Be that as it may, this court fixes the matter again on 13th of August 2025. It is observed that if the petitioner is not represented, the appropriate order will be passed.
Problem is what the PWD wants to start the process to reconstruct a RCC bridge, but because of
Is there stay? Not to construct?
they have communicated that because of pendency, they have not proceeded.
Okay, when do you want it?
Last week, if possible.
23rd of July?
Not.
And what is the other one?
But it was filed earlier at the point of time. The same prayer, my lord, allowing them to collect the toll, my lord.
Okay, anyways, they don't have a right to collect. On a public thing, they have no right. The right is always of the revenue department, isn't it?
Structured upon the donation from the town, my lord, by recovering the same, they are not going to return it to the public who have donated it. For their own purpose, my lord, they are using the money. There's their statement made that.
Yes, the matter comes after years.
Lordship, I missed the file today, Lordship. My name is not actually in a call list. But my instruction, telephone instruction is that, Lordship, the person, the other contractor has completed the work, Lordship, already, Lordship. The work has been done. So probably the matter has become work.
You have challenged what?
Yes, ma'am.
What have you challenged?
The order of cancellation, madam.
Then go file civil suit. No case. I can't help you. The work has been completed. One. Secondly, if you are aggrieved by anything, you go and file a civil court. I can't today say that, okay, allow you to do the work. Can you do the work today? No. Then, no. If I allow you today also to do the work, at that rate, you can't do the work. This is of 2022. We are in 2025. What to do? Dismiss with liberty to go to the civil court. The counsel appearing on behalf of the petitioner submits that taking into account the submission made by Mr. N. Upadhyay, the learned counsel appearing on behalf of the irrigation department, that pursuant to the cancellation, impugned cancellation work, the work which was allotted to the another contractor, the work has already been, the remaining work have already been completed by another contractor, comma. The petitioner would be well advised to approach the civil court for seeking damages in view of the illegal termination and cancellation. So taking into account the above, comma, the learned counsel therefore submitted that he may be permitted to withdraw the instant petition with a liberty without prejudice to the petitioner to approach the appropriate forum seeking damages. So taking into account the said submission, as well as the submission made by Mr. N. Upadhyay, the learned counsel, appearing on behalf of the irrigation department that the remaining work has already been completed by another contractor, comma, the instant writ petition stands closed on withdrawal, full stop. Liberty, however, would be there upon the petitioner, if so advised, to file a civil suit before the competent court of jurisdiction seeking damages, if so.
Oblige, Lordship.
Yes, Mr. Bora. I was looking for you for another matter, one of the contempt matters. Normally, I take up a contempt matters, I don't issue a notice when the council is present so that a chance may be given for them to do it. There was one item number where the GMC commissioner has been made a party. Just have a look at the item number 4 or 5. Akashdeep? Huh?
Yes, madam. Item number 6. I think.
Item number 7. 7, no?
Not 7, madam, 6. No. It's a
This one I suppose, Dr. M.S. Lakshmi Priya.
item number, my lord.
Who is the GMC commissioner now?
GMC, the new GMC commissioner has joined. His
Hey,
name-
this one, I think, Dr. M.S. Lakshmi Priya.
Yes, ma'am.
It seems so, no? Can you get hold of this lawyer, with SP Das, Ansuman Dekha or anybody, so that I can change that order to that effect, giving you one chance? Because what has happened in that case, within 6 months, you have given it was a consent order. That within 6 months, as per what has been called, there was a joint survey being made, you will make the payments. Now 6 months have elapsed. Giving instead issuance of notice, if you can
Lord.
take a decision, that would be fine.
I'll inform Mr. SP Das,
if you can find him by 12 o'clock, if you can find him, then ask him, then I'll make that change. And thereby, unnecessary issuing a notice is a headache to that official also. So that we can finish it off. Yes, what is this?
Ballot.
Oh, two petitions. What are
Yeah,
these?
Both are same scheme ballot. Payment to bill ballot.
Non-payment.
There was an inquiry conducted, my lord. After the inquiry, my lord, chief engineer, my lord, irrigation department was rejected to take action against some officials, my lord, as the instruction.
Non-payment of contractual deals.
Irrigation department.
What happened
There
in
was
this
some
case?
anomaly.
Now, this is one thing. This is an inquiry which you want to do it. That is your lookout. I'm not on that. But the question is whether he is entitled to the amount or not. Who are you?
But I was directed to take instruction from the CMO office, my lord, whether after inquiry, what the action has been passed.
Irrigation? No irrigation.
They just nothing ballot. Actually, what happened ballot? They have been made, they have been completed later on subsequently Chief Minister Vigilance. Initially, against the department, irrigation department, I filed suit. The irrigation department submitted affidavit ballot. And they've given some amount, paid some amount. They have no objection. Only thing they said that the matter, the file is not with them. It was handed over to Chief Minister Vigilance. Because of that, my lord, Chief Minister, after some discussion, when the matter reached an earlier, my lord, Chief Minister Vigilance Cell has been made party. And after that, my lord, probably this.
Now, what do they say in the affidavit?
My lord, irrigation department affidavit, my lord, you all should take my
Have they, who is respondent number 7?
response Chief Minister Vigilance Cell.
Okay, 6 is.
Subsequently made parties, my lord, in item number 20.
Irrigation
three.
department chief engineer, what do you say? They state that out of the total bill amount of event, only rupees so and so have already been paid to the payment petitioner, and for the payment of a demand was submitted in the month of so and so 2 FOCs were released for payment to all contractors. No, one thing is different. Who is for irrigation department? Just now I saw Mr. N. there. Where is he? Hello, we asked the chief, the additional, what is it? The irrigation department is by the additional chief secretary? The additional chief secretary irrigation to be present in the court, as they are not appearing. Chalo, none appears on behalf of the irrigation department when the matter is being called for. Full stop. Concern. Full stop. The grievance of the petitioner herein is on account of the non-payment of the dues which have been going on for of the petitioners in both the writ petition and in the writ petition. Is that on account that there is a non-payment of dues. Full stop. This court have duly taken note of the affidavit so filed by the irrigation department, wherein there is a categorical statement being made that certain amounts the petitioner is entitled to. However, on account of certain files being pending before the CMO Vigilance, no payments have been made. The payments could not be effected to the petitioner. Full stop. Nothing has been brought on record to the effect by the CM Vigilance Cell by way of any affidavit. Have you brought in a record? What do you say? That they are not entitled to?
I took a copy of the affidavit, just now I have been guest lodging.
I'm asking you, do you say that he is not entitled to?
No.
Then nothing has been stated in the affidavit filed by the CM Vigilance Cell that the petitioners are not entitled to. Have they stated?
Works are some.
Yes. anomalies in the work lordship and a CM office has directed the chief engineer to initiate disciplinary proceeding against the 5 persons lordship.
No, but are you saying that the petitioner are not entitled to?
Cannot say it right now, lordship.
Or are we to say that the counsel who appears for the CM vigilance cell is ignorant of what is there in the affidavit?
I don't.
Chalo.
Lordship,
Yeah.
today I've been. engaged.
Lekho. The counsel, Mr. So-and-so, he appears on behalf of the CM vigilance cell, submits that, oh, an affidavit has been filed by the CM vigilance cell, but he is ignorant of the contents of the said affidavit. Full stop. Considering that the irrigation department is not represented, as well as the counsel who appears for the CMO vigilance cell is not acquainted with the facts, comma, list this matter again on 30th of August, July 2025, comma, this court hopes and expects that on the next occasion, the counsel who represents the CM vigilance cell as well as the counsel who have been standing counsel for the irrigation department are aware of the facts before.
May I please, Your Lordship?
Why were you not present when the matter is there? Is he entitled to any amount?
The filing is with the service.
I'm asking you, is he entitled to any amount?
Yes, as per
So then pay. We are not concerned. If he's entitled to the amount, you have to pay because
the
this
filing
is in
is
violation of
the
Article
filing is
15.
the filing is diligence for investigation.
I'm not concerned to that effect. Whether you need an investigation, you cannot deprive somebody of the money. Every time any person wants to get a money, then the CM vigilance cell comes up and says that, okay, we'll hold the file. Can it happen like that?
As soon as the same business.
We are not concerned. CM vigilance cell counsel doesn't know head or tail anything about the matter. The order remains as it is. We have fixed it on 30th. Let's hope you expect on appear on that date. As of now, we know that both of you don't know anything. Absolutely no. No, none appears for the irrigation department when the matter is called. Yes, what is this? What are you challenging?
By this petition, the petitioner is selling the illegal and arbitrary decision-making process.
Search and seizure.
Yes, ma'am. Under the Electricity Act.
Then you paid the money.
They have paid the
My
money.
lord, in
They-
fact, we have paid the money as per the original final assessment order. Thereafter, what happened, my lord, when we approached the appellate authority of its own enhanced the assessed amount. That is, even without there being any counter claim or cross objection, so much to enhance the amount. That is outside the provision of the act.
So your case is that the appellate authority cannot enhance.
That is one aspect. And
And
the second is, so, even in the absence of any material connecting the petitioner with unauthorized use of electricity or theft of electricity, the assessment proceeding is illegally initiated. I can show from their documents itself, my lord, even the seal numbers which they have affixed, those are not matching from the seizure list, my lord. In fact, they handle the CTPT set behind the petitioner and they manipulated and the allegation is upon the petitioner. I can,
all the pleadings are complete.
Lordship, in fact, we had filed one affidavit, a preliminary affidavit.
Affidavit in opposition are filed by respond number 1, 2, and 3.
That was a,
It- Additional affidavit filed by the petitioner. Additional affidavit filed by respond numbers 1, 2, and 3. Anything more?
Lordship, in fact, the affidavit which we have filed, that's a preliminary affidavit only on the issue of
Maintainability.
maintainability and to resist the interim prayer. So perhaps, and after that, because the petitioners had approached APDC,
You have already filed one affidavit in opposition.
that was a preliminary affidavit.
Okay. Well, then what is this additional affidavit in opposition? And how many additional affidavit in opposition is
Because the
conceptualized
Lordship
in
has to
the
look
writ
at the uh,
proceeding?
affidavit, their affidavit is specifically on, though it, the, 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 E-court, the record shows that an affidavit in opposition is filed. It is only on the ground of maintainability and
Understood, but what is this additional
to
affidavit?
bring certain additional documents on
Then
record.
why you have not filed it?
Because,
It's a matter of 2022.
your lordship,
No, we impose a cost of 1 lakh.
if your lordship sees the previous order, the
No,
petitioner
no, no,
approached us
cost.
for a compromise.
I-
Lordship may kindly see the previous
No,
order.
the case of cost. If you are 2022 matter, it was for 3 years, the matter of assessment is pending. It is shameful.
Then lordship may, I am willing to argue the matter on the preliminary affidavit.
So you don't want to file an affidavit.
Because the issue of maintainability has been raised,
Okay.
that has to be
After
decided.
that, you don't want to file an affidavit, we'll take it on record.
Lordship, the issue of maintainability may be decided first.
No, absolutely no. You have filed that additional affidavit in the year 2022.
Yes.
This filed in a year, we are in 2025. Then
Lordship, the petitioners had approached us for a compromise in the matter. Lordship may have.
it's a different thing. Petitioner may withdraw. I'm not concerned with
Yes,
that. Do you want to file an affidavit in opposition or not? If you know, okay.
Lordship may not impose cost. Lordship may grant me 2 days time, I'll file the affidavit.
No, don't file. No, I'm recording the ACB or whatever maybe, they don't want to file the
Lordship,
affidavit.
in fact, we want to file an affidavit.
Then why haven't you filed it?
Because talks were going on regarding compromise.
We are not concerned with talks, when a matter is pending before the court. The matter came up out there on 9/4/2024,
Yes, Lordship
and
may,
the talks are going for 1.5 years.
Lordship may have a look at the order of 9/4/2024. It is recorded. that
Understood. Can the talks go on?
They cannot, obviously.
Okay. But it has been submitted by the councils appearing on behalf of both the parties that the matter has been going, talks between the parties are going on. Full stop. It is also seen that since 9/4/2024, the talks have been going on. Accordingly, the instant repetition, as the councils are not, accordingly, the instant repetition stands adjourned, sine die, to be listed only after due application being filed by both the parties to before the registry, that the matter has been, the talks, that there is no settlement which can be arrived at. Yes, what is this?
Regarding the allotment of soap in Lanka Municipal Market Law.
Allotment of
So, beta, soap law,
shop.
soap law.
What shop?
Actually, earlier petitioner also approached this honorable accordingly page 49 lordship deputy commissioner
Of
directed.
Vita in the newly constructed multi-story Lanka. And notice was issued in 2023, no affidavit filed.
Not applicable.
And who appears on behalf of the respondents? Which respondent is this? Panchayat?
Lordship now is a Lanka Municipal.
Urban Development Department,
Lordship.
Urban and Municipal Department, Deputy
But-
Commissioner, Lanka Municipal Board. Who is going to give it to you? Lanka.
Lordship, Lanka Municipal Board. Lordship.
Have the service been complete?
Service has been complete, but they have not yet appeared. Lordship.
And it's okay. We will say that they don't have any objection in your considering your application and allowing you the, what do you call, the vita. You want that only.
Beta lordship.
No,
Only that.
we go
because
on
they
the
have
question
provided
of-
others, Lordship.
We apply the principle of doctrine of non-traverse against the respondents. Chalo.
Uh,
Heard Mr. We finish it off.
Lordship,
No. 2022 matter, it doesn't look nice.
Some of the cases of Lanka Municipal Board, in some of the cases of Lanka Municipal Board, I appear. But in this case, I have no notice. If Lordship grants me time, I can take the instruction from the board.
From Lanka Municipal Board.
Municipal. In some
Mr. Dean at the Learned Council submits that he normally represents the Lanka Municipal Board in some other matters. He therefore submits that he may be permitted to obtain instructions in the instant matter. Mr. Considering, matter pertain as to whether the petitioner would be entitled for the vita
Yeah, okay. To be
in the
constructed
newly
Lanka
constructed
Municipal
multi-storied business center, Lanka. So taking into account the above, Mr. K. M. Mujumdar, the Learned Counsel, appearing on behalf of the petitioner, submits that a matter has been pending since last 3 years and requires an urgent disposal. So taking into account the above, is the matter on 30 July 2025. In the meantime, the stand of the Lanka Municipal Board be brought on record by way of an affidavit. The name of Mr. D. Nath be shown in the cause list. What is this? Non-payment?
No, no, no. I'm challenging the issue letter, work order at page 192.
Huh?
Annex 7,
What are you challenging?
the letter by which the work order was issued to the respondent number 5.
Work order,
Oh, yes, no.
interim,
Interim is there.
and test. Work order stayed. Of 2023 stayed, we are in 2025.
25.
Then,
The lordship, what happened, lordship, the respondent number 5, private respondent number 5 was served with a copy through justice service. He received those copy, lordship, but he has not appeared till date.
it's okay,
And he
no,
is
not
going to be
necessary.
arrested
What is
for
the challenge made here?
Challengement is lordship. He was invited on 4/2/2023 for item number, we are for item number 18, lordship, at page 27. At page 27. serial
Mr.
number
Bora,
18.
you are not in urgency?
No,
You don't have any urgency in spite of a stay?
no, this affidavit has been filed, my lord, on 16/5/2025. That this is a public interest matter, my lord, the irrigation project, my lord. The same time.
Now,
my
I
lord,
am asking
Yeah,
you,
there
do
is
you
urgency.
have an urgency or not?
There is no urgency, my lord.
Because there is a stay
There
operating.
is a stay operating.
Chalo, we finish it up tomorrow at 2 o'clock. Tomorrow at 2.
Yes, fine.
List the matter tomorrow at 2 p.m. An attempt shall be made to dispose of the petition.
Okay.
There's no sir, my lord.
Infructuous. Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submits the writ petition has become infructuous. What is your name? Huh? The name is there. Sure. Miss A. Begum. Okay. So taking into account the above, the instant reputation stands closed on withdrawal. Mr. S. Bottago appears on behalf of warrant correspondent.
Part paid, part yet not yet to be paid.
But
Last
here,
time they have,
but I need further one in time for filing the affidavit. Well, I have already drafted the affidavit. Well, here my instruction is that already the amount which has been paid to the petitioner, that calculation was not wrong. In fact, they have already paid in excess. So some detailed calculations are there. I'll bring it on record, Malad, by filing it.
Mr. D. Nath appearing on behalf of the. Your vetting has been going on for a long time.
Malad,
Then what is wrong with your vetting?
Malad,
Some people are vetting students with civil supplies, they are waiting for a long time.
I have sent some instructions. Again, I have said, I prefer one is that.
So list this matter again on 28 July 2025, comma. A last opportunity is being given to the respondents to bring on record their stand in the affidavit. So the affidavit has, if, it is observed that if no affidavit is filed, comma, this court shall proceed with the instant disposal of the instant petition on the basis of the materials already available on.
Similar.
Title,
This serial number is 12, only the list prepared. As per consider list prepared.
hey, Is he entitled to the amount?
Yes, sir. Yes, sir.
File an affidavit. Mr. Arthur Musari, appearing on behalf of the respondents, submits that the petitioner is entitled to the amount as claimed. That is to the amount, that is rupees 19,39,003. In that regard, he had placed certain documents. He had placed certain documents before this court, It would be advisable that the petitioner, that the respondents files an affidavit in that regard, admitting to the said affidavit. Admitting to the said amount, considering the above list this matter on 13th July 2025. In the meantime, the affidavit be filed by the respondents. This,
Here, respondent number one has filed their affidavit in opposition. But I have, but I have also received the instructions from my client. So I pray for 2 weeks' time for filing a reply to.
affidavit in reply.
In
Mr. Dina, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to file an affidavit in reply to the affidavit in opposition filed on 11/3/2025 by the respondent number one, taking into account the above, is there an interim order? Taking into account the above, list this matter again on 1st of August 2025. In the meantime, the reply affidavit be filed. Non-payment,
This matter will be disposed of, my lord. We have instruction that he has not submitted some documents and fund is also not available, my lord. Within time frame, my lord.
Huh?
Within 6 months or 3 months, matter will be, that may be paid, my lord. Direction will be
you are ready to pay within 3 months,
6 months at least, my lord.
6 months. 4,07,000.
After examining. his
What
claim.
examining? Do you admit to this amount or not?
In this letter, my lord, there is no specific admission, however,
Don't come up with all these things. Do you admit to this amount or not?
then I will take a specific instruction.
List this matter again on 30/7/2025, In the meantime, the respondents are directed to bring on record their stand as to whether the petitioner is entitled to the amount of rupees 4,07,330 as has been claimed in the instant requisition. None appears on behalf of the petitioner on call. List the matter after 4 weeks. Huh?
Mr. NJ Khatun is unwell, my lord. Therefore, he couldn't come to the court. Pay for adjournment.
Why?
Unwell, my lord. Mr. NJ Khatun here.
It's okay. I'm asking them only. Whether he's entitled to this 3 lakh.
If after the payment of it, 3 lakhs of.
No, 3 lakhs he has already got. 2 lakhs he is entitled to. That is why the requisition has been filed. What is your stand?
Lord.
You are appearing for whom? You are.
Behalf of S. Yogi.
No, I'm asking you whether he's entitled to the amount of rupees 2 lakhs or not. He's entitled to. Miss So-and-so appearing on behalf of the respondent numbers 1 and 2 categorically submits before this court that the petitioner is entitled to the amount of rupees 2 lakhs as has been claimed in the instant writ petition for completion of the construction of the waiting shed at Kamorgao, Somsan. Isn't it? Full stop. Considering the above, comma, this court therefore disposes of the instant writ petition with a specific direction upon the respondent numbers 1 and 2 to release the amount of rupees 2 lakhs to which the petitioner is entitled to within a period of 3 months from the date a certified copy of this order is served upon the petitioner. Considering the above, the instant writ petition stands disposed. Mr. So-and-so appears to have got voided.
Two weeks time to file a affidavit.
No stay?
No stay. One I was rejected on the last occasion.
Have you taken the decision on the petitioner's representation on 18/11/2024?
That was rejected, man. We want to file an affidavit, man.
You have filed an affidavit?
We will file in 2 weeks.
No, because on earlier occasion, it has been mentioned only that the petitioner's representation, you have been given 3 weeks' time to file affidavit, you have not filed it.
Because this IA was being heard, my lord. Their
What about the IA? We are not concerned with the IA. Here, the petitioner claims to be entitled to certain amount. What is the amount you are asking for? Representation, pending bill of 73 lakhs 57,932. Mr. I. Bottakur appearing on behalf of, what is the department?
Managing Director, Textbook Corporation.
Appearing on behalf of the respondent numbers,
1, 2.
respondent, all the respondent submits that a final chance may be granted for filing the affidavit in opposition of the respondents. Who stop taking into account the above lists this matter on 6th of August 2025, comma. The affidavit in opposition be filed by 4th of August 2025. Full stop. It is observed that if no affidavit in opposition is filed, comma, this court shall proceed with the disposal of the instant writ petition on the basis of the materials already available on record.
We are challenging time barred assessment order.
What are you challenging?
Time barred assessment order.
Oh. Then affidavit in opposition filed.
Yes, yes, right.
There is a stay.
Yes, yes.
What is your stand, Mr.
Lordship, you will see page 39. In fact, my lord, for my instruction, my lord, it was initiated within time.
Ah.
The financial year is, my lord, 2007 and 8.
Ah.
Though inadvertently in this notice, it has been mentioned as 9 and 10. It should be 7 and 8. We have stated in the affidavit. And it was issued on 3/10/2012. under section 40 says in my lord, it will have to be within 8 years from the date of the financial year which is taken up for assessment.
Where? Page
Page 39.
39.
It is a so-called under section 40.
On further scrutiny of your claim of tax exemption against sales under
CST.
section 2 of the CST, it appears that for rupees demand submitted by you are found to be defective as both the form do not contain the detail of supply order. So you have asked to appear before the undersigned and so forth in writing as to why the claim under so and so should not be rejected and that turnover of the demand should not be excluded. Tax at the rate of 4% under section 40. It should be for 7 and 8.
Yes, 7 and 8. There we have stated in the affidavit at para 7.
Then if it is 7 and 8, it becomes more barred
8 years. My lord.
8 years.
Till 16 we have, till April 16.
Then why is it, if the,
Well,
what is
it
it
is-
challenging here?
With the assessment order, my lord.
Assessment order was passed when?
22, my lord. Page 48, 49.
Now, this is what? What is page 45?
My lord,
That is
yes,
the
my lord.
subsequent notice.
Lordship will see reference, my lord. Reference, this office letter dated 3/10/2012. It is the same letter at page 39.
And
So my-
after that, why did you wait?
In fact, my lord, that's, my lord, that order was not passed, but it was initiated in 2012 itself.
No,
So
no,
it was
can you
within
keep
time.
on, by issuing a notice and thereupon, did you reply?
But he,
Yes,
he
yes, para 9
participated.
of, para
There are
9 of
9 years later that he participated.
Para 9 of my writ petition, that I said, pursuant to that notice, one of the partners of the firm visited, blood clarified blood, because earlier assessment all had already taken place. I had submitted my the blood text and they wanted to reopen it. And then blood, we explained it that it has been done. There is no illegality as such. It's the SOCA should not be given effect to. The matter ended there
All verbally?
verbally. Blood, we responded verbally 2012. And
The-
now all of a sudden
The officer
2022.
must have been very kind enough, when you issue a notice, I think the act stipulates that you need to submit a written reply.
That was the, my lord, Soko says so.
The records were there because they have already assessed it. I need not.
Understood, but isn't it required to have anything in writing? Anyways, but that is for 2009-10.
No, 7 in it, because though it
But
has
it's
been
been wrongly
inadvertently
been numbered
mentioned
as 910. It is for 7
7 and
We have also indicated. Now
Then-
they want to revive the so-called notice in 2022.
Again issue.
Yes, yes. Page
That-
45.
that page, lordship may see page
So
32.
either way, my lord, the time is barred. Because it's not from the date of issuance of so-called notice. It is the time limit is the passing of the assessment order, section 40.
Assessment order has to be passed within that time, na?
Yes, yes.
Says, my lord, no order of assessment or reassessment shall be made under subsection 1 after the expiry of 8 years from the end of the year in respect of which or part of which the tax is assessed.
It is not the initiation.
No.
It is the,
Passing of order.
it is the passing of the order.
Yes, and it is the case of reassessment.
Then, what case you have? Here's a good case. Huh? Okay, VETEC conduction. VETEC. And evaluated tax. We'll have it tomorrow.
Well,
2 o'clock, we finish
Sure.
it off. I'm still a bench one, so problem is that I don't have these books.
Fine.
I have to search it out. Okay, list the matter tomorrow at 2 p.m. In time order, pastor you shall continue to.
Wait,
This for non-payment of bills of rupees 44,67,663.
Yes, what is your stand?
Now, basically communication that it is
Huh?
under consideration. Under consideration before the authority regarding payment of their dues. Just now I received.
The consideration means when?
There is dispute or
Huh?
in a,
How much time?
3 weeks, let's say. 3 weeks. 3 weeks, within 3 weeks, I'll file a petition.
How much?
3 weeks, let's say.
The instant petition has been filed by the petitioner, being aggrieved by the non-payment of an amount of rupees 44,67,663. Full stop. It is relevant to observe that this court by an order dated 19/12/2024 had issued notice. Today, Mr. S. Dr. Dalan's Standing Counsel of the Revenue and Disaster Management Department has placed before this court an instruction issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department that the petitioner's case is under consideration of the respondent authorities. Considering the above, list this matter again on 8th of September 2025. In the meantime, the Revenue and Disaster Management Department is directed to process the is directed to ascertain as to whether the petitioner is entitled to the amount of rupees 44,67,663 or any amount in respect to this is a supply order.
Supply for
In respect to the supply order. And the same be placed before the court by filing an affidavit without fail. The instruction so placed before the court by Mr. S. Dotto is kept on record and marked with the letter X. What is this?
I may be allowed to withdraw this petition.
Withdraw?
Yes, Lordship.
Yeah.
The grievances has been withdrawn by.
They have not filed affidavit. Take a lakh.
No, Lordship. grievance-
First take 1 lakh for 2 matters and then withdraw.
Lordship, I'm not appearing in the other. It's a contempt petition, I'm not appearing.
What about the writ petition?
Writ petition, I am.
Then take 1 lakh. They've taken time from this court. Unnecessary. Mr. So-and-so appearing on behalf of the petitioner submits that he has instruction to take on the writ petition. He has instructions to withdraw the instant writ petition. Mr. K.P. Pathak appears on behalf of the respondents who's taking into account the above. The writ petition stands closed on withdrawal. Full stop. What is the contempt for?
Stop, Lordship.
Why?
Because grievance has been redressed, Lordship. Grievance has been redressed, Lordship.
The grievance has been redressed means why have you filed the contempt? Contempt cannot be dropped like this. No, the problem arises there. Disputed the entitlement to have his account settled and considering the limited nature in which his entitlement to understanding account. So you claim that you are entitled to certain amount.
Yes, Lordship.
Directing it to examine and verify the claim of the petitioner and appropriate order settling the claim. So there was a direction being passed that to verify.
Yes,
They
Lordship.
have verified
Yes, Lordship.
and whatever may be.
Yes, Lordship.
The learned counsel appearing on behalf of the petitioner submits that pursuant to the order passed by this court on 16/2/2018 in WPC number 734/2018, whereby there has been directions issued to examine and verify the claim of the petitioner, comma. The claim of the petitioner have been duly verified, and as such, nothing further remains in the instant contempt proceeding. Taking into account the above, the contempt proceeding stands dropped. Ayah sini kiba kon. Ayah so yet. Ayah thank you. Okay, ayah. Oh, not received. Okay, okay. None appears on behalf of the petitioner on contempt proceeding, none appears on behalf of the petitioner on call. Full stop. On the other hand, Mr. Esbora appears on behalf of the contemnants. Full
Amount
stop.
has been received by the sir.
Huh?
96 lakhs was there, 2023, 50 lakhs already been received. That is affidavit has been filed. And now, last order, my lord, there is a, complete the new incumbent, that is also not been done. In 2023, it was done, order was dated.
Mr. Esbora appears on behalf of
it
the
has been-
contemnant and submits that upon verification, an amount of rupees 50 lakhs have already been released to the petitioner, isn't it?
Yes, my lord. Way back in sanction order dated
Way
25,
back
8, 26.
on 25/8/2022, isn't it?
Yes.
He therefore submits that nothing further remains in the instant proceedings. Full stop. It is also seen that the respondent, that the petitioner on the earlier occasion sought for time for impleading, for filing an impleadment application. However, nothing has been filed. It appears that the petitioner's grievances stands redressed, have already been redressed. So accordingly, the contempt proceeding stands dropped.
Second stage for respondent number 2, it is the newly implemented.
Respond number 2.
So, yes, sir.
Yes, Borolen. Just now I saw some Borolen person here.
The board.
Mr. Esbora is there, na? Hey, you are also there. What is this? Non-compliance of what? Kamser Ali. Okay. Akash Deep. He's the principal secretary.
Yes, yes. He is the principal secretary.
You appear and obtain instructions. Mr. B. Chaudhary appears on behalf of the respondent number 2 and submits that he would obtain instruction as to whether the petitioner's grievances and as to whether the order passed by this court dated 17/8/2022 in WPC number 720/2022 have been complied with. Full stop. List this matter again on 18th of August 2025. The name of Mr. B. Chaudhary be shown in the cause list for appearing for the respond number 2.
So it's complied, its payment is made.
See, in the
That
morning,
payment is being made.
in the morning, if we had, he was about to close it, then you would not be appearing to the,
My lord, that number 5, my lord. That
This
serial
is?
number 5.
item number 44.
44, my lord.
Mr. So-and-so appears on behalf of the petitioner and Mr. So-and-so appears on behalf of the respondents. Respondent or respondents?
Respondents, respondents.
Plural? Petitioners and appears on behalf of the respondents. Mr. Ardot, the learned counsel submits that the order dated 2/5/2023 in WPC number, which one?
3585/2021.
3585/2021 have been duly complied with. And in that regard, have placed before this court the updated status of payment against the outstanding liabilities, which is kept on record and marked with the letter X. So taking into account the above, the instant contempt proceeding stands dropped. Same,
Same, my lord, is petition number 4125/21.
again, same paper.
No, no, it is different. My lord, here.
With petition number,
4125/21.
it will exclude, huh? Forty-six. 46.
What is, my lord, I am.
46 is what?
I'm not there.
You had to take instructions why he has not got 27,60,000.
Lordship, here, it was, Lordship, that of fund, as the fund was receiving the SOPD fund, Lordship, by the VTC authority, 5 lakhs was released to the petitioner. And remaining, Lordship, as and when we received the fund from the government in the SOPD category, Lordship,
When are you going to get it?
Lordship, as and when the
As and
government
when means
releases-
what?
the government
The
releases
government is not so good in making payment.
because Lordship, the
You
administrative,
will get everything except money.
Lordship,
Or should we have it after 10 years? The government may. You pay with interest.
Lordship,
No, we direct you, okay, you have the fund, get your fund ready, pay at 12% interest per annum.
Lordship, as per the policy decision of the PTC authority, list has been prepared in terms with Tamsir Ali. His serial number was at 106. And Lordship, as and when the fund was received, each of the person who were in the list, they were given a part of the amount, not because the administrative approval was for only 500 crores. And the contract was given by the erstwhile BTC authorities or government, Lordship, it exceeded that amount, administrative approval. That's why, Lordship, it's difficult to get the total amount at one go. So we are paying as and when the fund is received in each of the department to each of the contractor. Part payment, Lordship.
He's happy with it.
No, no, sir, I have not get a single final.
Lordship, 5 lakhs was given to it.
No, no, no.
So when are you paying this 27,60,000?
Lordship, out of 27, 5 lakhs was already paid.
When?
Lordship, I had given on the last occasion the
The
instruction.
last
that-
occasion, it says
Lordship, this was the-
27,60,000.
This was the sanction. This was the
Yeah,
sanction.
maybe sanction, but sanction is not mean that he paid the amount. He is saying that, submitting that he is paid.
Only 5 lakhs have been paid. This is on 1st of March.
Yes, Lordship.
Thereafter, he is entitled to another 27
Yes,
lakh
he is
60,000.
entitled, he will get it, Lordship.
When?
That's as and when the fund is available, Lordship. That's the issue.
So in your contract, when you allowed it, did you put a clause out there? The payment will be made as when the fund is available?
No, Lordship, that was done by the erstwhile BTC. government.
Erstwhile means there is no erstwhile BTC.
That's why, Lordship,
BTC is
we
what?
have inherited that liability and we are trying to.
Who means the
The
present minister?
New regime, new regime.
New regime. So,
Lordship.
so tomorrow again another new government is coming and the government said that earlier government must have done whatever maybe.
Lordship,
We are not going to
that
do
I can
anything.
say, but we are trying to make payment to each and every one, Lordship. Only the availability, because it is only, we are dependent on the state government fund, Lordship.
BTC has got a lot of money.
Lordship.
That day I saw one big BTC building out there in GK. Yes. Sell it. One or two rooms out there, sell. 27 lakh 60,000 you will get. You want to take 1, 2 rooms out there? It's a very big 4 or 6 story building. You want to take it? Give it to him. On one hand, you say you don't have money, but you have so much of properties.
That's
Really?
also right.
Give us an update. We'll have it on 11th of August. Make some payments. You have it, you sell some properties, you have got a lot of money. It is seen that by an order dated 5/5/2025, instructions were sought for from Mr. B. Chaudhary, the learned counsel appearing on behalf of the respondents as to why the remaining amount of rupees 27 lakh 60,000 have not been paid. Mr. B. Chaudhary, the learned counsel submits that though the petitioner is entitled to the said amount, but on account of dearth of funds, the BTC is not in a position to make the said payment. This court observes that the respondents are not in a position to make the payments. This court observes that the petitioner hearing is entitled to the amount upon completion of certain works. Under such circumstances, it is the duty on the part of the respondents to make the payment as earnestly as possible. Under such circumstances, this court fixes this matter on 18th of August 2025, on which date an update shall be made, update shall be provided as to whether the amount of rupees 27 lakh 60,000 have been released in favor of the petition.
Lordship, one thing on 5th of March, Lordship, I have produced this Machasan, and he sought for time whether that money has been received or not. If it has not been received, that 5 lakhs, Lordship, he may bring on record the non-receipt of that amount, because then we have to make inquiry.
Nothing has been paid, Lord.
Lordship,
I already
that was
submitted,
sanctioned.
nothing has been paid, Lord.
Nothing has been paid.
No, Lord.
That he may, because on 5th of March, he prayed before this honorable court that he
I have
will
not-
take instruction
In
whether
contempt
that
petition, I have
5 lakhs.
The
has been received.
order of 5th of March only shows one thing. You have to inquire when you are going to pay 27 lakh 60.
No, 5th of March, Lordship, the instruction.
There's no
that
other
I-
orders,
No,
only one
5th
order.
of March, Lordship, the instruction that I saw to your Lordship, that was shown and it was
If you
reflected,
have paid, file an affidavit stating that.
but he is still denying that he has.
Arey, you will be paying him through a bank account.
Because
here.
it's a financial.
Mr. B. Chaudhary, are you saying that you make payment by way of cash?
No, Lordship, he has to
pay,
collect the check.
no, you pay by
deposit
way of bank,
in his,
bank transfer.
yes,
So produce that document, enough. We'll see. You have paid that. You cannot come up out here and say that we don't have money.
no, the rest of the Lordship, it's there, that I will try to get. Right. Okay.
No affidavit.
My lord, we have already paid. Already
Huh?
released the amount. You have already released the amount.
Everything. None appears on behalf of the petitioner on call. Good stop. Mr. So-and-so. What is your name?
A Barbuja,
Appears on behalf of the respondent numbers 1, 2, and 3.
120.
1, 2, and 4. And submitted that the amount of rupees 16 lakhs 57,852 have already been released to the petitioner. And there is no further liability payable to the petitioner. Full stop. Full stop. Taking into account the above, it appears that the petitioner have therefore lost interest in the instant proceedings. Accordingly, the instant proceedings stands closed on for non-prosecution.
My lord, this is a petition for non-payment of this contractual bill. We have cleared the bill, ma'am. We have paid. I'm not pressing you.
সেই আগৰ সেই এওঁলোক দুজন এপিয়াৰ কৰা এইটো আছে এইটো এক্স কৰি দিব similar type order na
Similar type, my lord. In serial number 18, my lord. The writ petition amendment.
এইটো এক্স কৰি দিব not pressing বুলি নহব দেই dropping
This is writ petition, my lord. That is contempt. This is
this
a
is the repetition
writ petition, my lord.
okay oh this is not a contempt Leho. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner.
Respondent 1, 3, and 4, my lord.
Mr. So-and-so appears on behalf of the respondent numbers 1, 3,
3 and
and 4.
4, my lord.
Full stop. The petitioner herein have approached this court claiming an amount of rupees 1,52,72,995 against the supply of 25,062 packets of 2/60s merchandise bleached cotton hank yarn and 2/60 merchandise dyed cotton yarn in pursuance to a supply order dated 21/11/2016. Full stop. Mr. Ardor, the learned counsel appearing on behalf of the respondents submitted that the said amounts to which that the petitioner had been duly paid certain amount paid the amounts
Entire.
have duly been paid the entire amounts and that have been due upon verification have been paid as per his entitlement. So in that regard, he has placed before this court the updated status of payment to AG to the petitioner again to the
Serial number 18,
to the petitioner
Guwahati Industrial.
against the
Places.
outstanding liabilities. Full stop. The said document is kept on record and marked with the letter X. Mr. So-and-so appearing on behalf of the petitioner submits the petitioner have received the said amount. Considering the above, the instant writ petition therefore has become infructuous, for which the instant writ petition considering the amount above, it appears therefore that the petitioner's grievances have been duly redressed, and as such, nothing further remains to be adjudicated. In that view of the matter, the instant writ petition stands closed. What is this?
Non-payment of bill, my lord.
Non-payment of
Of
due.
Next are 5 and 6, that's the pending bill. Total amount is 5 lakh.
No, 5 and 6 is the material body, my lord.
Huh?
Mulberry Municipal Board is required to take a call.
Service upon Nalbari Municipal Board.
That is taken.
You take service by way of Dusty.
5 and 6.
The claim made in the instant writ petition is actually against the respondent numbers
Respondent
5 and 6 for non-payment of an amount of rupees 3,06,456 and 2,29,842. Full stop. However, none has appeared on behalf of the respondent numbers 5 and 6. Considering the above, this court directs the petitioner to effect service upon the respondent numbers 5 and 6 by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next date, list full stop. Next matter again on 1st of September 2025. In the meantime, the respondent number 5 and 6 as well as the other respondents shall bring on record their stand by filing the affidavits. What is this? So,
And one submission, your lordship, in the original writ petition, your lordship, Ministry of Jal Shakti is a party respondent, and the direction is to both the department, water resource as well as Ministry of Jal Shakti, Your Lordship, to clear the payment, Your Lordship. But in the contempt petition, only water resource has been made party, Your Lordship.
You have got the money from the union.
My lord, no, my lord.
Then why you are only making him them?
My lord,
Have you represented to the ministry?
no, my lord,
Jal Shakti?
it is directed in the respondent number
In
three.
view of that, there being an admission made by the respondent number 5, the respondent number 3 is directed to re-verify and thereafter take a decision with regard to whether the petitioner amount. In the event the respondent comes to a decision that the amount claimed is admitted, the direction passed in Iman which have been enumerated above shall be complied with. What is the direction passed? Now, you see, unless and until Ministry of Jal Shakti does not release it, then you should have given this.
The action is there is that.
You have not given the notice even to the Ministry of Jal Shakti.
If, submit notice.
You file your affidavit. He is not going to get any single penny in this manner. Okay. Miss Ardeka appears on behalf of all the respondents and submits that she would be filing the affidavit. Full stop. List this matter again on 22nd of September 2025. In the meantime, the affidavit in oppositions be filed on or before 17th of September 2025. What is this?
We are praying for a little modification of your lordship order.
Why? What has happened?
In fact, if my lord will come to the original order at page 18.
What are you asking for modification?
My lord, at paragraph 4, page 19. It is further made clear that upon the said amount of 60% being deposited, the petitioner herein would be entitled to release of the said amount subject to furnishing due security. But this, while my lord, they came up for modification of this order, while modifying, my lord, this page 29, instead of the security, your lordship has provided for an undertaking. And we find that, my lord, the petitioner may not be in a position to, my lord, in case the matter goes in our favor. So that is why we are praying that there should be some security. So, my lord,
I did it in presence of them. This is not a case of review. Reject. Go to the Supreme Court. Heard Mr. I. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Full stop. Learned senior counsel assisted by so-and-so appearing on behalf of the applicant. And Mr. So-and-so appears on behalf of the opposite party. Full stop. This is an application file seeking. Have you deposited the amount?
otherwise it is ready, man.
No, there is no, there is a direct.
The only problem is, my lord, if your lordship will just have a look at this one, just.
The said undertaking shall also specify how the applicant would be in a position to satisfy its undertaking, which is movable and unmovable. So he will be satisfying it.
Just one thing, but while making a prayer for modifying your lordship's original order, this was not even the prayer.
Even that was not his prayer that you are going to have you are going going to give it in the ICICI bank. Then don't make up with this type of submissions. He only stated out there that look here, we don't have it from a nationalized bank, we have it only from the ICICI bank. Didn't you make the submission? So then should I make the correction to that effect if we agree to the submission? Here the submission is this, kindly see number 3. This court further directs that instead of submission of a bank guarantee of a nationalized bank in favor of the Iman, it can be given from the ICICI bank. It is his application. Then also I made the change because here, this was a consented order. And because of the consented order, now you are seeking a review? My goodness. This was it.
Only to the extent of the undertaking.
Nothing doing. This is an application seeking modification of the order dated 13/6/2025, passed in IAC 857/2025. Full stop. The learned counsel senior counsel appearing on behalf of the appellant submitted, on behalf of the applicant submitted that in the original order, there was a direction that the petitioner was required, the opposite party was required to submit any form of security. However, in the subsequent order which was passed on 13/6/2025, it has been mentioned that the petition opposite party herein would be submitting an undertaking and as such seeks a modification. Full stop. The direction so passed herein, this court duly takes note of that the order dated 36/2025 passed in IAC 857/2025 was passed after duly taking into account both the parties, after hearing both the parties and in their presence. Full stop. The direction so passed therein, full stop. The modification which is now being sought for is in actuality seeking a review to the order dated 36/2025 in IAC 857/2025. Full stop. The ground, full stop. It is the opinion of this court that no grounds of review has been made out for which the instant application stands dismissed. Which one? You want to withdraw CRP-IO?
No, no,
Huh?
application I had CRPIO.
CRP-IO has been disposed of.
Yes, that is disposed of.
Yeah.
I
IA for what?
have a modification of an order, modification of an order, final order.
What is the modification?
Since matter is the file. To the defendants to make an applications to for release of that. In this case, my lord, what happened, my lord, only the present petitioner is the now participate defendant number 4 only participating in the proceeding, madam, because of that order, as the defendants has been mentioned.
I have directed the whom to deposit 25,000.
Plaintiff petitioner, madam. Plaintiff in the.
I've asked him, yeah, and the further observed the defendant should be at liberty to file application before the order for release of the amount. Then what is wrong?
4 is now participating in the case, and other are performer respondents now. Because of that, I have submitted an application for Lanet Court below is hesitated to release the amount to me. The Lanet Court below is of the view that to release the amount to all the defendants, including the performer defendants.
So that is one you want the change. So he has deposited the 25,000. Okay. This is the heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant. Full stop. Mr. F.U. Borbuha appears on behalf of the respondent. Full stop. The instant application has been filed seeking a clarification as to whether the amount of rupees 25,000 which was directed to be deposited by the petitioner in CRP number 48/2025 would only be applicable, would only be released to the defendant number 4, who is only participating in the said writ proceeding, in the said proceedings. But here, P.K. Kolita was appearing for whom?
Waiting for the petition.
All the respondents.
Only for the respondent number one. Verina, Georgina.
Here is the WS filed by three parties. One, WS filed by 1, 2, 3.
Respondent number one, M.A. Hussain was appearing. M.A. Hussain S. Zaman S. Alam.
Senior advocate, Mr. P.K. Kolita.
S. H. Zaman. Okay, only respondent number one was appearing. And he was the defendant number 4. It is relevant to take note of that in the said proceedings being CRP IO number 48/2025, only the respondent number 1 was represented, and who is the defendant number 4 in the suit. This court therefore clarifies that the application seeking withdrawal of the amount of rupees 25,000 would only be required to be filed by the respondent number 1 in CRP IO number 48/2025, who is the defendant number 4 in title suit number 29/2015. On the basis of the instant clarification, the instant application stands disposed.
Thank you.